Good afternoon, everyone.
Good afternoon.
I'd like to thank all of you for coming to this event to help celebrate my dean, Irvine Chemerinsky's important and brilliant new book, The Case Against the Supreme Court. My name is Song Richardson. I'm a new professor here at the College of Law, and it is my great pleasure to introduce both Professor Rick Hasson and our dean. So Professor Hasson is the Chancellor's Professor of Law and Political Science here at the law school. He is an expert in issues of election law, and he's well qualified to interview Dean Chemerinsky because he too has published numerous books, including his 2012 book titled The Voting Wars. Now, turning to Dean Chemerinsky, I know that he hates to be introduced, and he's someone who obviously needs no introduction, but I feel compelled just to say a few brief words. I obviously can't speak about all of his accomplishments because then I would be here for an hour before we ever got to the interview. So as you know, Dean Chemerinsky is a nationally recognized expert on issues of constitutional law, civil rights, and civil liberties. He's also a prolific scholar. He's written 8 books, it might be 9 now, and over 200 law review articles. He also frequently contributes to public discourses on issues of both local and national importance, somehow finding the time to pen op-eds and to be interviewed by the media. Fourth, his students tell me all the time what an incredible and fabulous teacher he is because he continues to teach despite everything he does. And finally, he argues frequently before numerous courts, including the U.S. Supreme Court. On a more personal note, Dean Chemerinsky is one of my own legal heroes. He's not afraid to speak his mind and to fight for what he believes is just and for what he believes is right. In addition to that, he's just an incredibly nice and incredibly humble person. So his book has been described as brilliant, thought-provoking, disturbing, and enraging. So without further ado, I hope that all of you will join me in giving a very warm welcome to Professor Rick Hasson and Dean Irvine Chemerinsky.
Thank you.
Well, thank you. It's an honor to have this role and to be able to ask these questions. I really enjoyed the book, and I don't know if it's because it was the first book I downloaded on my new iPad, or because I read it on my way to our 25th anniversary trip to Hawaii. So it was a great experience. Loved the book. So I'm going to start off with some softball questions because you're my boss, and I'm going to move into more challenging questions because I have tenure. So let's just start. And Song made reference to your energy level. I know that if I write to you at 5 in the morning when I get up very early because I have a long ride into the office, or if I write to you at 11 o'clock at night, you're writing me back. How did you write this book? How long did it take you to write this book? Did you have to do any research to write this book, or did you write this book off the top of your head?
Let me start by giving some thanks. Most of all to Song Richardson. This was Song's idea. I admit that I was embarrassed by it, but was thrilled that Song persisted in asking me to do this. And I want to thank Rick for being willing to do these questions, our wonderful staff for organizing it, and most of all, I want to thank all of you for coming. One of the reasons that's a bit embarrassing to me is they're selling my book outside, and I don't want you to think that we set this up so I can profit from you. I will make a contribution to the scholarship fund here for every book that's sold. So for, let's say, I'll contribute $5 to our scholarship fund for every book that's sold outside, and I'll have them calculated. So it's my way of thanking you for being here and for supporting the book. Just a few years ago, Rick, I was teaching the case of Buck versus Bell that involved the Supreme Court approving the involuntary sterilization of a woman. I begin the book with the story of that. And it's the case where Justice Oliver Wendell Holmes, in some of the most insensitive language anywhere in the United States report, said, 3 generations of imbeciles is enough. And my students were understandably very outraged by that. And I realized that I found myself making excuses for the Supreme Court. And as I thought about it, I realized that far too often in my teaching and in my writing, I was making excuses for the Supreme Court. And that if I thought about the Supreme Court more critically, I realized that the court has so often failed through American history, often in the most important tasks and important times. And so I decided I want to write the book and had the title and the thesis before anything else, and was fortunate that Viking wanted to purchase the book and to publish it. As you may know, publishers generally aren't very strict about deadlines, and I had a deadline of the manuscript being due in September of 2013, and I was working on it. I definitely was doing research on it, but was not taking the deadline very seriously. And in mid-July of 2013, the book agent who had sold this to Viking said that they want the manuscript and they want it in September, and she implied that if they didn't get it, they weren't interested, and though it wasn't a big advance, there was some advance, and they would want the money back. And talked to my wife and said, is it realistic to try to finish this book between now, which was mid-July, and mid-September? And I decided I would try and work very hard and finish the book and had it on the publisher's desk on time on September 16th, only to get an email from her saying, I'm snowed under, I'll get back to you soon. 3 weeks later, she writes me and says, oh, we'll get back to you soon. And 3 weeks later, then finally, she begins to get comments on the book. So the answer to the question is, in one sense, it's a book that I've been working on for all 35 years I've been a law professor. In another sense, it was a book where a lot of the writing was done waking up exceptionally early over a couple of months period of time. And Catherine can attest to all of this.
Oh, you mentioned the Buck case, and I just thought, for those who have not yet read the book, if you could just briefly just state what your book's central argument is and what led you there.
Sure. I think I stated the thesis. It's that the Supreme Court has often failed through American history, often at its most important tasks and often the most important times. I believe that the Supreme Court's preeminent role is to enforce the Constitution. I think the court plays a particularly special role when it comes to protecting minorities. Majorities can generally protect themselves through the political process. It's minorities who need the Constitution and who need the courts. For the framers, they would have been most concerned about political and religious minorities. Today, we would talk about racial and ethnic, sexual orientation minorities, as well as political and religious minorities. I think the Constitution is especially important in times of crisis. I think the framers knew this. They knew from world history that in times of crisis, there'd be a temptation to centralize power, a tendency towards repression. And so I think as we evaluate the court, the place to begin is, how is it done in protecting minorities? How is it done in times of crisis?
So the two main critiques of the book, which you yourself anticipate, one is that the book will be perceived as what you call liberal whining. And the other is that it's nihilistic, suggesting that there's nothing to the Supreme Court's jurisprudence but the ideological judging of the majority, a results-oriented judging. And I want to explore each of these in turn, starting with the latter point. So in 2005, Professor Lawrence Tribe, who was the author of the competing constitutional law treatise, American Constitutional Law, announced that he was giving up the project. He said that he had, quote, come to the sobering realization that no treatise, in my sense of the term, can be true to this moment in our constitutional history, to its conflicts, innovations, and complexity. His sense of what the treatise meant is a broad vision of constitutional law with various parts and themes analyzed according to organizing themes, a synthesis of some enduring value. In your book, you say, quote, liberal and conservative justices alike defer to the legislature when they agree with it, and they're willing to overrule it when they disagree. Let's stop pretending it is any other way. So have you reached the same point as Tribe? And if so, aside from your children's tuition, why do you continue writing the treatise? And why do you continue teaching constitutional law? Why not teach a subject that is not so ideologically driven?
There is so much in that question.
I told you the softballs are over.
I obviously don't agree with Tribe in many ways. including on January 2nd, I sent off the new edition of the Constitutional Law Treatise and feel enormous relief to have done that. So yes, I'm continuing to do the treatise, not just because it helps my kids' tuition fund, it doesn't pay that much.
Make the book a little thicker. It's only about 1,500 pages.
The reason for writing the treatise is it's my opportunity to try to teach a larger audience. So the treatise, I have the opportunity to try to explain the law and policies of constitutional law to law students elsewhere, maybe to law professors, maybe to lawyers, even occasionally to judges. I don't accept the end part of your question, that constitutional law is more ideologically driven than other areas of law. I think it's more visible and more visibly ideological, but not more ideological. Let me give you an example. Think of tort law. And think of how in the 19th century, tort law doctrines were developed like assumption of risk, the fellow servant doctrine, and contributory negligence, that virtually always made it that employers won and injured employees lost. Or think about in the area of contract law, how difficult it is for consumers to win, say, unconscionability claims against merchants. That's because courts over time have made ideological choices to favor employers over employees, merchants over consumers. Now, because that comes from many different courts over a long period of time, it's less visibly ideological. When it comes to the Supreme Court, it's one body issuing decisions, so the ideological orientation is more visible. The place I disagree with Professor Tribe is I don't think it's more ideological today than it's ever been before. The Constitution is written in broad language. What's cruel and unusual punishment? What's equal protection or due process? Inevitably, constitutional law requires balancing of competing interests. No rights are absolute. How justices, how judges in lower courts are going to engage in that balancing or that interpretation is inevitably and has always been a function of who are those justices and judges? What are their life experiences? What are their values?
Well, is it possible that Tribe was getting at the middle of the court? That is, at the time he said this, O'Connor was the middle of the court. Today, Kennedy's the middle of the court. And for either one, you might say that there's a lack of even ideological consistency. And so maybe the problem is not that judging is ideological, but that it's incoherent.
But I don't know what you mean by coherent. I don't believe that the Supreme Court has ever taken a consistent position in terms of constitutional or statutory interpretation. That I believe there's always been inconsistencies across doctrines and even within doctrines. And I don't believe that Justice Kennedy is more ideologically inconsistent than Justice O'Connor or than the swing justices who came before her, say Justice Lewis Powell or Justice Byron White. Now let me say, I have enormous regard for Larry Tribe. I was his research assistant in law school, and yet I've never understood why he believes that the court is more inconsistent today or more ideologically driven today, and I'm not sure how that relates to his choice to not continue the treatise.
Good for sales, though. So you express disappointment with the Supreme Court throughout history, and perhaps what I found most surprising in the book, tremendous disappointment about the Warren Court. I'm going to come back to that in a few minutes, but I want to ask you why, given this disappointment, you still support judicial review. That is, the idea that courts ultimately are going to decide the meaning of the Constitution, at least how it is going to be enforced in the United States. And so I want to contrast this with, say, the approach of Harvard's Mark Tushnet, who calls for taking the Constitution away from the courts. I think that was the name of his book. Or former Stanford Dean Larry Kramer, who calls for popular constitutionalism. In your book, you reject these solutions as simply shifting the power to the lower courts, which you say, I think quite persuasively, is no better than having one Supreme Court. But why not something more radical, like legislative supremacy, like the way we had things in England until quite recently?
I think the Supreme Court in Marbury versus Madison got it right. The Constitution is about limiting the government. Those limits have meaning only if they're enforced. You can't trust the legislature or the executive to enforce the Constitution as against themselves. I've spent basically the last 40 years representing people who have no chance of succeeding in the legislative process. I represented a homeless man before the Supreme Court. I've argued death penalty appeals. I've represented a Guantanamo detainee. I've argued many cases in favor of criminal defendants. My clients aren't going to win in the political process. Their constitutional rights aren't going to be upheld. When's the last time that a state legislature adopted a law to expand the rights of criminal defendants? When's the last time a state legislature adopted a law to make sure that the rights of prisoners are better protected? For people like my clients, it's really the courts or nothing. They may often lose in the Supreme Court, but they have so little chance of having their rights upheld in the political process. And so my answer is, let's think of ways of improving the court to make it more likely to fill what I see as a key mission, protecting people like this, the politically powerless in society.
Now, you mentioned that your clients often don't win. I think your record at the Supreme Court is perfect, isn't it?
I won once.
Okay. Is that not discouraging?
Of course it is.
Why keep going? I've stopped writing amicus briefs at the Supreme Court because I think that it's kind of irrelevant to what's going to end up happening.
Here I'd speak to our students. I think we have only two choices, to give up or to fight harder. And I don't think we can give up. So I may lose when I'm arguing for a Guantanamo detainee. I may lose when I'm representing a homeless person in the Supreme Court. I've lost all the death penalty appeals that I've argued. But I don't think we can give up. And I don't think there's any other forum where they have a chance.
Okay, so moving from nihilism to liberal whining. So, and this is your term, let me be clear. So you want your book not to be seen as liberal whining. So you say if you look back over history, if you look to cases like Korematsu, which upheld the internment of Japanese Americans during World War II, even conservatives would agree with you. Maybe not about the cases today, but looking back. So at bottom, you contend there's kind of universal agreement with your proposition that the main purpose of the Supreme Court is to protect minorities against the tyranny of the majority. You state, quote, "I believe the two preeminent purposes of the court are to protect the rights of minorities who cannot rely on the political process and to uphold the Constitution in the face of any repressive desires of political majorities." There are no doubt people who would disagree with you that these are the primary purposes of the court. A conservative, for example, might say that the preeminent purpose of the court is to protect individuals from government tyranny and overreaching. So let's start with this topic. Do you accept the fact that there are other legitimate ways of describing the preeminent purpose of the court? And if you do, what does that mean in terms of your case against the Supreme Court?
Of course, there are many ways of articulating the preeminent purpose of the Supreme Court. Let me take the one that you attribute to conservatives. It's to protect individuals against government power. I agree with that goal. I don't think it's in any way inconsistent with the goals that I've articulated. And then the question is my critique of the court just, as you keep putting it, liberal whining, or is it something else? The first third of the book is a historical critique of the Supreme Court. And I believe that most of what I say there in terms of the case against the Supreme Court, both liberals and conservatives would agree with. So the first chapter of the book after introduction focused on the Supreme Court in race through American history. I believe when we evaluate the court, whether liberals or conservatives, we have to talk about how the Supreme Court has done with regard to race. From 1787, when the Constitution was written, until 1865, that's a period of 78 years, the Supreme Court aggressively enforced the institution of slavery and protected the rights of slave owners. There wasn't a single decision where the court chipped away at the institution of slavery or protected the rights of slaves. From 1896 to 1954, and that's a period of 58 years, the court articulated and aggressively enforced separate but equal, sanctioning the Jim Crow laws that segregated every aspect of Southern life. So whether I take what you articulate as the conservative goal or the way I put it, the Supreme Court from both the liberal and the conservative position was a dismal failure in race during these times.
And what about in current times? Let's take the Second Amendment gun rights. So I take it that your position would not necessarily be the same as conservatives, that preventing people from owning all means of firearms would be government tyranny.
Let me stay within my critique about race. And I could talk about current times, though here there's more likely to be disagreement between liberals and conservatives. And I'll pick as my example here your field of voting. On June 25th, 2013, in Shelby County, Alabama versus Holder, the Supreme Court declared unconstitutional a key provision of the Voting Rights Act of 1965. This is the first time since the 19th century that the Supreme Court has declared unconstitutional a federal civil rights law dealing with race. I think I can make a very strong case, and you've made a very strong case, that this was misguided. Misguided in terms of conservative as well as liberal principles. Conservatives have long said they want to defer to the political process. The Voting Rights Act extension was passed by the Senate 98-0. There were 33 no votes in the House of Representatives. President George W. Bush signed it into law. Where in that case was the conservative deference to the political process?
And on gun rights?
I don't talk about gun rights in the book. I don't use it as part of the case against the Supreme Court. But it certainly illustrates how inevitably ideological Supreme Court interpretation is. The Second Amendment says, a well-regulated militia, being necessary to a free state, the right of the people to keep and bear arms shall not be infringed. From 1791, when it was ratified, until 2008, the Supreme Court always interpreted it as being a protection of a right to have guns for the purpose of militia service. There weren't a lot of Supreme Court cases. The last was United States v. Miller in 1939, but it was always interpreted as a right to have guns for purpose of militia service. In 2008, in District of Columbia versus Heller, the Supreme Court said that the Second Amendment protects the right of individuals to have guns, at least in their homes, for the sake of security. It was 5-4. The 5 conservative justices took the individual rights position. The 4 more liberal justices took the position that always been taken that the Second Amendment means what it says, it's right to have guns for militia service. It's all then a reflection of how much the ideology of the justices influences where they come to. I don't know where the debate on guns in our society became so much conservatives are for gun rights, liberals are for gun control, but that was reflected in where the Supreme Court came out.
Okay, so even accepting your statement that the preeminent purpose is to protect the rights of defenseless minorities, how do you respond to Terry Eastland? He's the editor of the Weekly Standard. He wrote a review of your book in the Wall Street Journal, and he said, Mr. Chemerinsky worries that his book will be seen as a liberal complaint about the court. But this perception is inevitable, if only because he omits from his evaluation the Supreme Court case that was arguably the worst, legally and morally, of the 20th century, Roe versus Wade. In that case, the court read into the Constitution a woman's right to abortion, a decision that nullified 46 state laws outlawing abortion. Their demise helped pave the way for millions of abortions that have occurred since then. In this case, Mr. Chemerinsky simply says Roe was enormously controversial. Is Eastland right? If one takes the view, as Eastland does, that fetuses have constitutional rights, and today we're on the 42nd anniversary of Roe versus Wade, where do you stand with your preeminent test as to Roe? And I know that you've said that you've addressed Roe in other books, so that's a fair reason not to address it in this book. But I was wondering if you could speak to that question.
I think I can make a case against the Supreme Court by pointing to the Supreme Court's mistakes, by my criteria, over the course of American history, including the 20th century. I'm not saying that every Supreme Court decision has been a mistake. That would be a ludicrous claim. I'm saying that when you look, for example, at what the Supreme Court has done with race, or how the Supreme Court has handled times of crisis, or you look at the Lochner era from the 1890s to 1937, or you look at the current Roberts Court in decisions like Citizens United, or the Rehnquist Court in Bush versus Gore, or how the court so protected the rights of business at the expense of individuals, or you look how the court has closed the courthouse door to those who are injured. There's a powerful case against the Supreme Court. There's also cases in the book that I praise. I talk about United States versus Nixon being an illustration of why we need the court. I praise its recent decision in United States versus Windsor. And there's many other cases that I don't discuss, but I don't think not discussing them undermines my central thesis. I don't discuss Roe versus Wade in this book, and the main reason is I've discussed it elsewhere. In my last book, I have a long discussion why I think Roe versus Wade was correctly decided, and I was trying to say things I hadn't said before. But I don't think the fact that I don't discuss Roe versus Wade undercuts the force of what I do say is a case against the Supreme Court.
The other critique that Eastland raises is that he says that you think majorities should always lose. He says, quote, "It appears in every case in which the rights of a minority and the rights of the majority to govern are pitted against each other in a lawsuit, Mr. Chemerinsky believes that minority rights should win. He points to no case with approval in which the justices sided with the majority against minority rights. He also never presents a hypothetical conflict in which he believes the majority should prevail. Mr. Chemerinsky does not say how he would reconcile minority rights and majority power, but his commitment to minority rights seems absolute. This, despite the fact that he insists in his book that no constitutional rights are absolute. So can you think of cases where the majority should prevail or should have prevailed? Is this a fair criticism of the book?
Oh, I don't think it's a fair criticism at all. There are obviously instances where I think that the majority should win and instances where I think the minority should win. I think where the court should uphold laws and instances where the court should strike it down. Take the example we mentioned a moment ago. With regard to the Voting Rights Act of 1965, I think the court should have sided with what the majority of Congress did there, overwhelmingly passing the law. When it comes to rights of criminal defendants, I certainly don't believe that a criminal defendant should win every claim. There are instances where I think the courts rightly rule against criminal defendants. They're favoring the majority over the minority. Or take one of the areas where I'd most applaud the Warren Court, where it ordered the reapportionment of state legislatures. Earl Warren said that that was the decision he was most proud of all the ones that came down during his tenure, because it made the political process work. There it was the Supreme Court allowing the majority in a state to govern, not allowing a minority to capture the political process. To me, that's the most powerful example to refute what Eastland accuses me of.
I'm glad you brought up the Warren Court, because that brings me to a different set of criticisms. And I'm thinking here of David Savage's review of your book, which was much more sympathetic than Eastland's. But my sense of reading David is that he thinks you're too hard on the court. For example, you criticize the Warren Court for not moving fast enough on desegregation. That's probably your main example of the failure of the Warren Court. But he points to the protection of criminal defendants' rights in an unprecedented way, the one person, one vote rule that you just mentioned. So is it fair to say, if you looked overall, that the court has been a failure? And let's just limit this to the Warren Court. Are you expecting too much of a branch of government that has no army, that has no constituencies?
Let me again state the thesis of the book. It's that the Supreme Court has often failed, often in the most important times, often in the most important ways. I'm not making an overall judgment because I don't know how to make such an overall judgment. I don't know how you could add up all of the successes and all the failures and meaningful weigh them. In terms of the Warren Court, there's much to applaud that the Warren Court did. It brought about an end to the Jim Crow laws. It held in Brown versus Board of Education that separate can never be equal in the realm of public education, and that did end the segregation, that led to the end of the segregation, that it segregated every aspect of Southern life. The court did, during the Warren era, greatly expand voting rights, such as in the one-person, one-vote area, striking down the poll tax, and other areas. The court did incorporate most of the Bill of Rights into the 14th Amendment and thus apply them to the states. The court did greatly expand the right of criminal defendants who otherwise wouldn't be protected. And yet I also think that there are areas where the Warren Court didn't do as much as it could have or should have. And I point to two examples in the book. One is with regard to school desegregation. Now, you can start with where we are now. American public schools are terribly separate and unequal, and they're becoming more separate and more equal at an accelerating rate. I think the Supreme Court deserves a great deal of the blame with that. Some of the blame starts with the Warren Court. It could have ordered an immediate end to desegregation. It could have prescribed the tools for doing so. But instead, in 1955, what we know as Brown 2, it just said it was going to send the cases back to the lower courts to bring about desegregation, quote, with all deliberate speed. If you look at the New York Times the day after that decision, the southern states claimed it as an immediate victory. It was perceived at that time as a loss for the NAACP. And it wasn't until 17 years after Brown, in Swan versus Charlotte-Mecklenburg Board of Education in 1971, that the court finally began to prescribe the tools the court should use for desegregation. And then you talk about what the Supreme Court did in cases like San Antonio Board of Education versus Rodriguez in 1973, holding there's no right to education, and inequalities in school funding don't violate the Constitution. In Milliken versus Bradley in 1974, saying you can't have inter-district remedies which make desegregation almost impossible. I think the court deserves a lot of the blame for the current separate and unequal schools. The other example I point to where I think the Warren Court didn't do as much as it could have or should have is with regard to the right to counsel. We rightly all applaud Gideon versus Wainwright, the 1963 Supreme Court case that held that anybody being tried in a state court with a possible prison sentence had a right to a lawyer. But today, all over the country, people are being tried, including in capital cases, with grossly inadequate lawyers. I alluded to appeals that I handled in capital cases. And in those cases, the criminal defendants were represented by people you wouldn't want representing you if you had a traffic ticket. The inadequacies of counsel were so tremendous. Well, what the Warren Court did in Gideon versus Wainwright was create an unfunded mandate. It said to the states, provide lawyers for everybody, but it created no enforcement mechanism and no mechanism to ensure competent counsel.
Toward the end of your book, you discuss many ways in which you think the Supreme Court could be improved, including a move to 18-year terms for the Supreme Court. And so putting aside the merit of that proposal, we could talk about that if you want to, I want to talk about the here to there question. So how do we in a polarized society, polarized Congress, gridlock Congress, get any movement towards any change of the Supreme Court? To what extent will the eventual retirement of Justice Kennedy, now the swing median justice, provide an opening on these issues? I mean, even your cajoling did not get Justice Ginsburg to retire from the Supreme Court, although it probably stopped any of them from getting any of our students from getting a clerkship with her. How can we get movement on the issue of term limits, which actually has support from Stephen Calabrese and others in the Federal Society, Jim Lindgren? There looks like there are people on the left and the right who think this would be a good idea.
Again, there's so many great questions there.
I was only given 30 minutes by song, so I got to pack it in.
Let me try to unpack it, and let me start with term limits. Life expectancy today is thankfully a lot longer than it was in 1787. Clarence Thomas was confirmed for the Supreme Court in 1991 when he was 43 years old. If he remains on the court until he's 90, the age at which Justice Stevens retired, he will be a justice for 47 years. So this doesn't sound ideological. John Roberts and Elena Kagan were each 50 when they were confirmed for the court. So if they stayed till they're 90, they'll be there for 40 years. That's too much power to be exercised by a single person for too long a period of time. It also risks, as we saw occur early in the 20th century, a court that is wildly out of tune with the times. Also, too much depends now on the accident of history as to when there's vacancies. Richard Nixon had 4 vacancies in his first 2 years as president. Jimmy Carter had no vacancies in his 4 years as president. 18-year non-renewable terms would mean that every president would get a vacancy every 2 years. Now, I make many proposals for change. None of the others would require a constitutional amendment. This is the only proposal I make that would require a constitutional amendment. So by definition, it's the least likely to happen. And yet, you mentioned, for example, conservatives like Stephen Calabrese and Jim Lindgren. I'll mention one, Texas Governor Rick Perry. Can we all stipulate Texas Governor Rick Perry is a conservative? He, in 2012, proposed 18-year non-renewable terms. I've gotten the chance to speak at times about the book. I gave a talk at the University of California, Santa Barbara, and about 700 people in the audience. The only time I got interrupted by applause is when I said I think there should be term limits for Supreme Court justices. So when you've got liberals and conservatives and widespread support, maybe as the idea catches on, it really can happen.
And finally, before we open it up to some audience questions, this current Supreme Court term is shaping up to be a monumental one. Now, you never know. Cases go in strange directions. Sometimes they disappear. But we could potentially have rulings on that could end the subsidies for health insurance under the Affordable Care Act. We might or we might not have a right to same-sex marriage nationally. There are important criminal law cases. In every area of the law, the Supreme Court seems to be holding the lever of power. What can people as individuals do to affect the way in which the country moves when the Supreme Court is the most unaccountable institution?
The way in which we hold the Supreme Court politically accountable is through the appointments process. The one political check that exists on the court is who presidents nominate, and then, of course, there's the political check of the confirmation process. I believe that the 2016 presidential election could be the most important in a long time with regard to the future of the Supreme Court. Justice Ginsburg turns 82 this year. Justice Scalia and Kennedy turns 79 this year. Justice Breyer turns 77 this year. Over the last several decades, most justices have left the court in their early 80s. There are occasional exceptions on each side of that. Justice Stevens didn't leave the court until he was 90. Justice O'Connor left when she was 75. But I could go through all of the vacancies in the last 50 years, and you see overwhelmingly their justices in their early 80s. That then means that the person who's elected in November 2016 is likely, even if it's a one-term president, certainly if it's a two-term president, to have 4 seats to fill on the Supreme Court. Every issue we want to talk about, and every that you've alluded to and the ones we haven't talked to, is likely then to have its ultimate outcome for decades to come to determine about who's elected president in 2016. So what can we do? I think it's really important for people to get out the word to others, individually in the groups they're part of, how much this presidential election means for the composition of the Supreme Court in the future and for all of our rights in the future. That's our way to have a political check on the court.
All right, so we're going to open it up now for questions, and we don't have that much time. And so 2 ground rules. 1, keep it brief, and 2, keep it a question. So if you're interested in asking a question, just raise your hand. Yes?
If it wasn't the Warren Court that was the best court we ever had, whose was it?
Oh, I'm supposed to repeat the question so that they can be heard on the recording or in the other room. So if it wasn't the Warren Court that was the best court, which was the best court?
Let me say, as I hopefully said, there's an enormous amount I applaud about the Warren Court. I just want to be clear, I also think there are areas where it could have and should have done more. If you ask me what was the best court in history, I'd have to say the John Marshall Court. After all, it was Marbury versus Madison in 1803 that created the power of judicial review. The power of courts to review the constitutionality of statutes and executive actions isn't mentioned in the text of the Constitution. It was Marbury versus Madison that established that authority. It was McCulloch versus Maryland that established the principles of federalism. Gibbons versus Ogden that established the broad reach of Congress's commerce power. It laid the blueprint for the government that we've had ever since, including today.
Yes?
Quick question in regards to, I believe, a case you were referring to, Baker versus Carr.
Mm-hmm.
Was this actually a political question that they essentially resolved?
So the question is Baker versus Carr, which was the case that opened up these one-person, one-vote cases to be heard by the courts. Was this a political question? I take by that you mean that should not have been reached by the court.
After World War II, there was a case called Colgrove versus Green that brought a challenge to the malapportionment of legislatures on the grounds that it violated a provision in the Constitution that says the United States shall guarantee each state a Republican form of government. And the Supreme Court said, that's left to the political process. In Baker versus Carr in 1962, the Supreme Court said that malapportioned legislatures could be challenged on the grounds that they deny equal protection. And it was a follow-up case, Reynolds versus Sims, that then articulated the rule that whenever you have an elected body, all districts must be about the same in population size. I think Earl Warren was right to regard this as one of his great triumphs as Chief Justice, because here it was the Supreme Court making the political process work. What you had in states was very malapportioned legislatures. You might have one district where 25,000 people elect a representative, and another district where 100,000 people elected a representative. Those in the latter district obviously had their political influence diluted. But the legislators in the malapportioned legislature weren't about to vote themselves out of power. They weren't going to redraw the lines. One person, one vote is about the essence of equal protection in the political process. John Hart Ely, in a book called Democracy and Distrust, one of the most famous books about constitutional law written in my career, talks about why this was exactly what the Supreme Court should have been doing, reinforcing the democratic process. So I think the court was right in saying this can't be left to the political process. This is a place where the political process couldn't work, and this is a place where the courts needed to be there to ensure equal protection.
Yes.
You talked a little about Brown, and I was wondering, a lot of what people say the strength of Brown is that it's a unanimous decision. How does that square with the fact that you don't think the court went far enough, and how do you think that would have changed the racial compositions of schools and segregation had the board not been unanimous and probably went forward?
Let me just repeat the question. So the question is about the unanimity of Brown, and to paraphrase, was there a trade-off there, and was that worth it to have that unanimity, even if it led to perhaps a weaker ruling than you would have liked?
I think it's important here to separate what's commonly referred to as Brown 1, the decision from May 17th, 1954, and Brown 2, the case about remedies that was decided in 1955. I understand completely why Earl Warren believed that Brown 1 had to be unanimous. He thought it essential to send a message that separate can never be equal in the realm of public education. It's interesting about Brown 2. Brown 2 did very little. The NAACP wanted the court to order an immediate end to segregated schools, and the court didn't do so. The court didn't prescribe timetables. It didn't give guidelines. It didn't outline the ways of achieving desegregation. It just said, go do this with all deliberate speed. And as you know from class, I've always said that I think all deliberate speed is an oxymoron, like jumbo shrimp or airplane food. I mean, deliberate and speed are antonyms of one another. John Paul Stevens wrote a book a few years ago, I think it's called 5 Chiefs, and he reflects on the different chiefs. And Justice Stevens says he thinks it was wrong for the Supreme Court in Brown 2 to choose unanimity over specificity. And I've long believed that, and hearing Justice Stevens say that lends, I think, some credibility to my position. There's no doubt that southern states were going to massively resist desegregation. Doesn't matter whether Brown 2 was 9-0 or 7-2. Still, there was going to be massive resistance. But I wonder if the Supreme Court had prescribed timetables, given guidelines, outlined what the lower courts would do, if it couldn't have hastened some of the desegregation. The court didn't begin, I mean, it wasn't until 1964, a decade after Brown, that the court finally said there'd been all too much deliberation and not enough speed. And as I already mentioned, it wasn't until 17 years after Brown that the court finally prescribed what the lower court should do to effectuate desegregation. We can never know the counterfactual of what didn't happen, but I've got to believe that the court could have done more. And I think that that's been true of the Supreme Court, certainly after the Warren Court.
I want to end this with a last set of questions. On July 13th, coming up this summer, we'll have our 5th annual Supreme Court Term in Review event. It'll feature the Dean, Professor Richardson, as well as Linda Greenhouse, who used to be the New York Times reporter, now at Yale Law School, still writes a column for the Times, as well as Sixth Circuit Judge Jeff Sutton, who was the author of the same-sex marriage opinion that the Supreme Court is currently reviewing, as well as Kannan Shanmugam, who is a top Supreme Court litigator. So they're going to come together. We'll probably be in the Student Center. You'll get an invitation, go out in May or June. And it's going to be a big term. And I'm wondering if you could just give us your predictions. Where are we going to be on same-sex marriage, Obamacare, and everything else that comes before the court?
Sure. Some of you have heard me say that predictions are free and worth what they cost. We'll all know by the end of June, so what's the point of predicting now? You may have also heard me say that he who lives by the crystal ball has to learn to eat ground glass, which makes me reluctant to do predictions. Also, when I do predictions like this, I invoke the memory of my late grandmother, When she was alive and she would see a pregnant woman, she would always guess the gender of the coming baby. If she got it right, she'd never let you hear the end of it. If she got it wrong, she would never mention it again. So I offer the predictions in that vein, and let me take the two examples you mentioned. The first concerns the Affordable Care Act. The case is King versus Burwell. The Affordable Care Act says that those who are of, I'm going to call them low middle income. And the reason I phrase it this way, the Affordable Care Act wants to make sure that health care is affordable to everybody. It says that states had to include within their Medicaid programs those within 133% of the poverty level. For those above that level, what it said was if they purchased insurance in a, quote, state-established exchange, they would get a tax credit, and it's the tax credit that would make the health care affordable to them. The Affordable Care Act also says every state shall establish an exchange, but if a state doesn't do so, then the federal government can establish an exchange for those states. To this point, 16 states have established exchanges, and those who are of this income range who purchase insurance from those state-established exchanges get a tax credit, and they will continue to get the tax credit no matter what the Supreme Court does in this case. In the other 34 states, the federal government, pursuant to the statute, has come in and created an exchange. The question is, if a person purchases insurance in a state where the federal government has created an exchange, do they still get the tax credit? On the same day in July, two federal courts of appeals came to conflicting conclusions. The United States Court of Appeals for the District of Columbia Circuit said the statute has to be read literally. State-established exchange means state-established exchange. If a person purchases insurance from a federally established exchange, they don't get the tax credit. The Fourth Circuit in King versus Burwell said statutes have to be interpreted to effectuate their purpose. Deference has to be given to agencies like the IRS that have interpreted the statute, and it's clear that Congress wanted people in this income range to get the tax credit, and that created the mechanism for the exchange through the federal government. The Supreme Court granted cert in the Fourth Circuit case. Now I've got to give my prediction. I think the Supreme Court 5-4 is going to reverse the Fourth Circuit. It's not the result I'd like to see them come to. My conclusion is based on, in 2012, in National Federation of Independent Business versus Sebelius, 4 justices, Scalia, Kennedy, Thomas, and Alito, would have declared the entire Affordable Care Act unconstitutional. It was Chief Justice Roberts who saved it by finding that the individual mandate was a tax within the meaning of Congress's taxing power. I don't think Chief Justice Roberts is going to save this aspect of the law. I think it is too alluring for the conservatives to be able to say, follow the literal language. It's a state-established exchange, and Congress doesn't like that. Well, of course, Congress could change the statute. But that's my prediction, 5-4 in that way. As to the marriage equality case, I'll also make a prediction. I think the Supreme Court is going to say 5-4 and maybe even 6-3 that state laws that prohibit marriage equality deny equal protection. I think that Justice Kennedy is going to write, joined by Ginsburg, Breyer, Sotomayor, and Kagan, and I can even see Chief Justice Roberts going along with the majority in this. Why do I say that? There have been 3 Supreme Court cases in history advancing rights for gays and lesbians. Romer v. Evans in 1996, Lawrence v. Texas in 2003, and United States v. Windsor in 2013. Do you know who wrote the majority opinion in all of those cases? Anthony Kennedy. I have to believe, I think most believe, that he sees his longest lasting legacy is advancing rights of gays and lesbians. He says in his opinion in United States v. Windsor that laws denying marriage equality serve no legitimate purpose. He said that about Section 3 of the Defense of Marriage Act. I think that's what he's likely to say here. It's inconceivable to me that Justice Ginsburg, Breyer, Sotomayor, and Kagan wouldn't come to the same conclusion. Also, the posture is different today than even it was in 2013. Right now, in 36 states, gay and lesbian couples have the right to marry, and most of them because of court decisions. The question is less, is the Supreme Court going to extend it, and more, is the Supreme Court going to take this right away from people? The Supreme Court, by waiting, is no longer the leader on this issue. It's simply following what almost every lower court in the country has done. And if that doesn't persuade you, I think ultimately for these justices, and even for John Roberts, the question is, do they want to write the next Plessy versus Ferguson, or do they want to write the next Brown versus Board of Education? There's no doubt where the world is going on this issue. 17 countries, including some predominantly Catholic countries, now allow marriage equality. It's hard to articulate what's the legitimate purpose served by denying marriage equality. And that's why I think it may even be 6-3 to say that state laws that deny marriage equality violate equal protection.
So before everyone leaves and before we thank Rick and Irwin one more time for this fabulous interview, I want to thank a few people and then give a few logistics. So I cannot leave this room without thanking all of the people who made this possible, some of whom are in the room today. Brandy Stewart, Charles Cannon, Colleen Terracani, Donna Mumford, Iris Yokoi, Jessica Weimer, Liz Schrader, Marina Harrison, Stacy Tran, and Jeff Latta. Thank you so much for helping put this event together. So once again, thank all of you for coming, and thank you so much, Rick and Erwin Chemerinsky.